Hello, I'm attorney Randolph Rice, a Maryland DUI defense attorney. Today we're going to answer the question, should I request an MVA hearing after a DUI arrest? Now a lot of that depends on what type of action or what type of things do you do when you're arrested for a DUI. Obviously when you get pulled over, the officer is going to try to ask you to take some field sobriety tests. If they then arrest you and you take you back to the precinct or the police station, they're going to offer you a form called a DR-15. They're going to either read it to you or you're going to read it. And it advises you the consequences of taking a test or not taking a test. Now, we refer to a test, we're talking about either a breath test or a blood test. Now, the results of those tests, and if you take the test, will determine if you need to request an MVA hearing. So let's assume first off that you don't take the test or you refuse to take the breath test or the blood test back at the precinct. You've got a couple of options. The first option is you can accept the suspension. Now it depends on how many prior refusals you've had in the past. If you've had one refusal in the past, there's a certain set period of time, and you can look at that form, that DR-15 form, and it'll explain how long your license would be suspended. That suspension starts on the 46th day after the DUI arrest. You can also elect to participate in what's called the Ignition Interlock Program. That's a program where you have, within 30 days, you have a device placed in your vehicle. You blow into that device when you start the vehicle and as you're driving the vehicle, and you have to keep that in your vehicle for 1 year. Now, if you didn't take the test and you want to request an MVA hearing, the only reason you'd be doing that is to go in and challenge either the fact that you weren't driving or the results of the test. There's only 7 areas that you can challenge the test under. You want to make sure you talk to a lawyer before you request an MVA hearing if you refuse to take the test, because you may not have an issue to argue at the MVA hearing, and you may save that $150 that you have to pay for the MVA hearing request. Now let's assume you did take the test. Depending on the results of the test, that will determine what type of hearing, or if you do want to have a hearing or not. If you blew under a .08, so .07 and .06, there are no administrative penalties. You'll keep your license. You'll be able to continue to drive. If you blew between a .08 and .14, so under .15, you can request a hearing to go in and have a restricted license. You want to make sure you hire a lawyer for that, because you need to have certain documentation to present to the MVA or the administrative law judge for the restricted license. You can also obviously accept the suspension, or you can participate in the Ignition Interlock Program. The last one is if you took the test and you blew over a .15, your options are pretty limited. You can either elect to take the suspension, or you can elect to participate in the Ignition Interlock Program. If you've been charged with DUI and you're trying to make the determination if you should request an MVA hearing, contact a lawyer as soon as possible, because there are some time limits by which you have to respond to the MVA and request that hearing. You can call my office 24 hours a day, 7 days a week, to request a free consultation and go over these issues and discuss what's the best option for your DUI arrest.